Section 7. The right to information. The right of the people to information on matters of public concern shall be recognized. Access to official records and to documents and paper pertaining to official acts, transactions, or decisions, as well as to government research data used as basis for policy development, shall be afforded the citizen subject to such limitations as may be provided by law. Right to information on matters of public concern. The right of access in the above provision implements the right to information. The arguments given for the inclusion Section 6 now Section 7 in the 1973 Constitutions are: Number 1. It is in consonance with the principle of popular sovereignty. In a democratic society, the sovereign people have the right of access to the records of their government. Number 2. It will enable the people to participate more effectively in governmental affairs, especially in questioning the acts of the authorities. It will make the denunciation of government more factual, responsible, and effective. Number 4. It will provide a deterrent to the commission of venalities because of the resulting awareness of officials that their acts will be exposed to the full light of public scrutiny. Lastly, it will reduce public suspicion of officials and thus foster rapport and harmony between the government and the people. In view of Section 7, there can be no doubt as to the constitutionality of any law making the refusal to give such information or denial of access thereto a punishable offense. Scope of the right. Number 1. The right embraces all public records. Number 2. It is limited to citizens only but is without prejudice to the right of alliance to have access to records of cases where they are litigants. And lastly, its exercise is subject to such limitations as may be provided by law. There are also limitations on the right. It is recognized that records involving the security of the state or which are confidential in character should be accepted. Presently, certain public records are declared confidential either by law or by administrative regulations. Instances of this are income tax returns under the National Internal Revenue Code, the condition or business of banks under the central bank, accounts pertaining to military intelligence funds and certain army records, and disbarment proceedings. Any law which prohibits disclosure of information by government agencies must strike a healthy balance between the need to afford protection to vital secrets affecting national interest or security and the imperative of safeguarding the basic right of the people to know about the activities of their government. In line with the constitutional policy to enhance free flow of information and to promote transparency in the conduct of public affairs, the disclosure of information must be the general rule, not the exception. The burden is on the government to justify the withholding of information or document, not on the person requesting it. The next one is the Section 8, which is the right to form association. The right of the people, including those employed and the unemployed, the public and private sectors, to form unions, associations, or societies for purposes not contrary to law shall not be abridged. The right to form associations is the freedom to organize or to be a member of any group or association, union, or society, and to adopt the rules which the members judge most appropriate to achieve their purpose. Let's take a look at the purpose of the guarantee. Number one, undoubtedly, the purpose of the constitutional guarantee is to encourage the formation of voluntary associations so that through the cooperative activities of individuals, the welfare of the nation may be advanced and the government may thereby receive assistance in its ever increasing public service activities. Number two, by enabling individuals to unite in the performance of tasks which singly they would be unable to accomplish, such associations relieve the government of the vast burden. The needs of the social body seek satisfaction in one form or the other, and if they are not secured by voluntary means, the assistance of the government will inevitably be invoked. The limitations on the right to form associations or societies may be abridged or interfered with by the state in the exercise of its police power. This is the meaning of the phrase for purposes not contrary to law. Even without the qualification, however, it is deemed to exist by virtue of the inherent power of the state to protect and preserve its existence. But unless an association or society could be shown to create an imminent danger to public order, public peace, public morals, or public safety, there is no justification for abridging the right to form unions, associations, or societies. Section 9. Essential or inherent powers of government. Private property shall not be taken for public use without just compensation. The totality of governmental powers is contained with three great powers, namely power of eminent domain, police power, and power of taxation. These powers are similar in the following respects. Number one, they all respect upon necessity because there can be no effective government without them. Number two, they are inherent in sovereignty, hence, they can be exercised even without being expressly granted in the Constitution, although the conditions for their exercise may be regulated and limited by the Constitution and by law. Number three, they are ways by which the state interferes with private rights and property. Number four, they are all legislative in character. And lastly, number five, they all presuppose an equivalent compensation received directly or indirectly by the person affected by the exercise of these powers by the government. The question is, what is eminent domain? So, eminent domain is the right or power of the state or of those to whom the power has been lawfully delegated to take or expropriate private property for public use upon paying to the owner or just compensation to be ascertained according to law. Here are the conditions for or limitations upon its exercise. They are existence of public use, payment of just compensation, observance of due process of law in the taking. Let's take a look at the existence of public use. Public use may be identified with public benefit, public utility, or public advantage. It may be identified with whatever is beneficially employed for the community. That the expropriation of a land may actually benefit only a few families does not diminish its public use character. It is of no moment of that the land sought to be expropriated is of small area. Let's say, for example, less than half a hectare only. If the property is taken by a private corporation like Meralco, a public utility given the power of eminent domain, to enable it to furnish the public with some necessity or convenience like electricity, the use is public. The next one is payment of just compensation. Under the local government code, the amount to be paid for the expropriated property shall be determined by the proper court, based on the fair market value at the time of the taking of the property. The owner may contest in court the value determined by the assessor. And lastly, observance of due process of law in the taking. Procedural due process requires that the owner shall have due notice and hearing in the expropriation proceedings. The second great power that the government contained is the police power. Police power has been referred to as the power of the state to enact such laws or regulations in relation to persons and property as may promote public health, public morals, public safety, and the general welfare and convenience of the people. It has been negatively put forth as the inherent and plenary power in the state which enables it to prohibit and all things hurtful to the comfort, safety, and welfare of society. The illustrations of police power statutes or ordinances are given below. Public health, those regulating the medical profession, providing for the segregation of lepers, providing maternity leave for working women, limiting the working hours to 8, requiring every building or premises to be connected with a sanitary sewer system, prohibiting the sale of fresh meat, except in refrigerated establishments outside the public markets, in etc. The next one is the public morals, those punishing vagrancy and prostitution, prohibiting gambling, providing a license tax for maintenance or operation of public dance halls, punishing usury, and etc. The next one is the public safety, those requiring a license for the right to drive motor vehicles, providing for the closure of certain streets to traffic of animal-drawn vehicles, requiring compulsory military service, prohibiting the carrying of concealed deadly weapons, authorizing the demolition of buildings or improvements which constitute a fire hazard, and etc. The last one is the general welfare and convenience, those requiring compulsory registration of lands, authorizing the removal of billboards offensive to sight, penalizing the turning loose of large cattle and permitting them to run loose in streets and plazas of municipalities, regulating the slaughter for human consumption of large cattle still fit for agricultural work, regulating distance between gasoline stations, regulating prices of commodities and rents of houses, and etc. Another great power of the government is the power of taxation. It is the power of the state to impose charge or burden upon persons, property, or property rights for the use and support of the government to enable it to discharge its appropriate functions. Taxation is necessary to enable the state to exercise its police power to promote the general welfare. But before we begin, let's define what is taxes. Taxes are the enforced proportional contributions from persons and property levied by the law-making body of the state by virtue of its sovereignty for the support of the government and all public needs. They are the financial burdens or charges imposed by the government upon person or property to raise revenue for public purpose or purposes. Let's take a look at the distinctions among the three powers. They are among others the following. Number 1. As to authority which exercises the power. Taxation and police power are exercised only by the government, while the exercise of the power of eminent domain may be granted to public service companies. Second one is as to purpose. In taxation, the property, generally in the form of money, is taken for the support of the government, in eminent domain, for public use, and in police power, the property is taken or destroyed for the purpose of promoting the general welfare. Number 3, as to effect. In taxation, the money contributed becomes part of public funds. In eminent domain, there is a transfer of the right to property, whether it be ownership or a lesser right. And in police power, there is no such transfer. At most, there is a restraint in the injurious use of property. Number 4, as to persons affected. Taxation and usually police power operate upon a community or a class of individuals, while eminent domain operates on a individual as the owner of a particular property. The last one is as to benefits received. In taxation, it is assumed that the individual receives the equivalent of the tax in the form of benefits and protection he receives from the government. In eminent domain, he receives just compensation for the property expropriated. And in police power, the compensation of the individual is not immediate, and usually annoyance and financial loss are caused to him, leaving the reward to be reaped through his altruistic recognition that the restraint is for the public good. Let us now proceed with the section 10, which is the obligations of a contract. No law impairing the obligation of contracts shall be passed. The obligation of a contract is the law or duty which binds the parties to perform their agreement according to its terms or intent. If its agreement is not contrary to law, morals, good customs, public order, or public policy. It is the duty of the contractors to fulfill the promises stated in the contract. Let's say, for example, a contract of sale. It is the obligations of the buyer to pay the price that he or she ordered, and it is also the obligation of the seller to deliver the thing that the buyer has ordered. Scope of terms, law, and contract. The law, the enactment of which is prohibited, includes executive and administrative orders of the President, administrative orders issued by heads of departments, and ordinances enacted by local governments. The guarantee is not violated by court decisions or by acts of boards of officers acting in a quasi-judicial capacity like a judge. The contract, the obligation of which is secured against impairment under the Constitution, includes contracts entered into by the government. An example of impairment by law is when a tax exemption based on a contract entered into by the government is revoked by a later taxing statute. The state, when contracting, does so upon the same terms as a private individual or corporation, and may not plead its sovereignty as justification in impairing a contractual obligation which it has assumed. A contract which is entitled to protection against impairment must be a valid one. So what's the purpose of non-impairment prohibition? The prohibition is intended to protect creditors, to assure the fulfillment of lawful promises, and to guard the integrity of contractual obligations. Business problems with the rise of contracts were not stable and bindings, and if the legislature can pass a law impairing an obligation entered into legally, the provision implements the constitutional right to freedom of contract.